Hello, my name is Peter Bricks. I'm a debtor bankruptcy attorney in Atlanta, Georgia. I have offices in Dunwoody, Woodstock, Cumming, and Jonesboro. I'm here to talk to you today about why your Chapter 7 bankruptcy might still be open even though you've received your discharge. But first, I want to issue this disclaimer. I'm a debt relief agency proudly assisting consumers in filing bankruptcy under the U.S. Bankruptcy Code. I'd have to meet with you individually to offer you applicable and accurate legal advice. There's no attorney-client relationship with the viewer of this message. So what I'm talking about today is why you might have received a discharge, but your case is open. It doesn't make sense to you because you filed to get that discharge, you got the discharge, isn't that the end of it? Not necessarily. Um, there are basically two main elements to Chapter 7, which is can you get a discharge of your debt and can you keep all your stuff? So breaking it down, the first one, can you get a discharge of all your debt? You have to remember there's certain debt that is the discharge is inapplicable to. You filed bankruptcy in December 2013. Your 2012 income taxes are non-dischargeable by law. They're not old enough to be discharged. There are other non-dischargeable debts like student loan, almost always student loan debt. You could have some other debt like child support or alimony that's non-dischargeable. So sometimes someone will file a Chapter 7 even though 80% of their debt's non-dischargeable. Conversely, someone else will file a Chapter 7 who every single penny of their debt is dischargeable. So that's one part of that dischargeability equation. The second part is, was there some debt that was dischargeable but you chose not to discharge it by reaffirming the debt? Most common example would be a car payment or a mortgage. You chose to keep the debt by reaffirming. It's a whole nother discussion blog whether that makes sense, but you chose to keep it by reaffirming. Therefore, you could have discharged it, but you decided not to. Then there's also other debt that is dischargeable, let's say a credit card debt, and unless the creditor takes an affirmative action to argue its dischargeability by filing an adversary proceeding, it is going to be discharged. Now, if the creditor does file an adversary proceeding, and this is going to happen quite infrequently, it very rarely happens with a credit card, it'll depend on your specific conduct. Um, Theoretically, you could settle that, or you could have lost, and the debt was deemed non-dischargeable. But once we get out of that, regardless of that, whether you, for instance, reaffirm a debt or you have non-dischargeable debt, you could still get a discharge order. It just doesn't apply to those debts. So once you get the discharge order, is your case closed? Not necessarily. Majority of the time in Chapter 7, when you get your discharge, it is closed. Why is that? Because the other element of the Chapter 7, was there anything for your trustee to seize as an asset to repay creditors? In a typical Chapter 7 case, it's what's called a no asset case. You were allowed to exempt a certain amount of stuff. You were under that exemption, and therefore there were no assets to liquidate, and you were a no asset case. Usually, in a pretty simple one, and this will of course vary by trustee and by district, your trustee, after you meet with them, which is about a month after you file the case, would file a no asset report, meaning you get to keep all your stuff. If that's the case, and you get that no asset report, let's say a week after you have your meeting of creditors, you cannot get discharged till at least 60 days beyond the meeting of creditors. So since the no asset report was filed earlier than you or can even by law receive a discharge, when you do get a discharge, your case will close. That will happen at the same time. So if your case is not closed when you got your discharge, it's because your trustee is investigating the possibility of recovery of assets. Now, who would they be investigating the possibility of the recovery of assets from? Either you, because you brought too many assets into the case, or a third party who you at some point transferred some of your assets away, whether it was legitimate or not, and the trustee is trying to recoup that asset for the benefit of all your creditors. It could have been a legitimate payment of a debt that, because of preference timelines, could be recouped. It could have been a fraudulent conveyance that was not disclosed, of course, then you're probably getting your discharge denied. But the point is, just because you get your discharge does not mean that your case closed. And if your case isn't closed, that means there at least is still a possibility there could be an asset recovered from you or a third party. Now, just because your case is open after discharge does not mean it's going to happen. Um, you very well, I've seen it plenty where the client gets discharged in January, and then come March, the trustee files that no asset report, and then the case closes at that time. So if the case is open, even though you've received your discharge, it's probably a good idea to touch base with your attorney and ask why it's still open, or if, say, you're pro se, touching base with the trustee, and just finding out, what is the asset out there that the trustee thinks exists, and that'll cover why your Chapter 7 is still open after your discharge.